This courtroom hearing starts as a simple probation violation, but within minutes, it turns into pure courtroom chaos. Michael Matson stands before Judge Simpson accused of one basic issue, failing to report to probation. But instead of addressing the violation, Matson launches into a string of legal arguments rooted in sovereign citizen ideology, instantly shifting the tone of the hearing. The judge calmly explains Matson's right to an attorney, but the defendant responds with a confusing request. He doesn't want full legal representation, only a public defender to help him fill out paperwork. Judge Simpson shuts this down immediately, making it clear that the court doesn't provide part-time lawyers for convenience. That's when things really start to spiral. Matson begins questioning the judge's authority, even demanding proof of Judge Simpson's oath of office. Clearly familiar with these tactics, the judge doesn't miss a beat, stating that sovereign citizen arguments have already been rejected in his courtroom, and they won't be entertained today. But Matson isn't done. He demands that a state police sergeant appear in uniform to testify about arrest procedures, a request the judge firmly denies, explaining that arrest protocols have nothing to do with failing to report for probation. When that doesn't work, Matson insists on his right to a jury trial, another claim swiftly corrected by the judge, who explains that probation violation hearings do not involve juries. As interruptions continue and Matson repeatedly talks over the court, Judge Simpson is forced to mute his microphone multiple times just to maintain order. In the end, the judge regains control, sets the next court date, and brings the hearing to a close, leaving behind a tense reminder of what happens when misinformation collides with the reality of the legal system.
I am required to advise you at all stages of the proceeding that you do have a right to be represented by an attorney, and if you can't afford an attorney, the court will appoint one for you at public expense. Do you understand that?
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney or not. Yes, sir.
Okay. You've previously waived that right. As I said, I have to advise you that at every stage of the hearing. So I have to ask you again, would you like to be represented by an attorney at this point?
As I started to say, Your Honor, I don't want the representation. However, I will use the help of handling paperwork due to my means here and having access to certain things in paperwork. I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
All right. So you've previously been arraigned on the probation violation. Do you know how you want to proceed? So your options are you can plead to it if you want, which means you'd be admitting guilt. The other option is that I can set it for a hearing and we can have a hearing on the matter, and then I'll decide based on the evidence submitted at that hearing.
Your Honor, all due respect, I wish, are you working under oath of office today, sir?
Sir, I'm not going to answer these questions or deal with this. We've dealt with you before and your sovereign citizen arguments. I've rejected them all.
Citizen.
Sir, do not interrupt me. Do you want to have a hearing or do you want to plead to
I'll take your silence under your oath, Your Honor.
Okay. Do you want to have a hearing or do you want to plead?
I want the hearing. I want to go to trial. I want to go within the 90 days to a trial or sooner.
All right, so Sierra, we'll need about a 1 hour hearing on a probation violation.
As well as I'd like you to have the arresting officers that arrested me on that day. I would like their sergeant to be dressed in uniform and at that trial on that day as well.
Will go more smoothly if you are here in person, so we will have you in person here from the jail.
All right, exactly what the hearing is going to be on that day.
So you've been charged with a violation of the terms of your probation.
Yeah.
For failing to report. So the hearing is going to be to determine whether or not you failed to report.
Okay, so it's going to be the trial that day.
Correct.
Okay, can I have the state police sergeant there at that trial?
What state police sergeant?
The state police sergeant of the arresting officers on the night of my arrest.
Who are the arresting officers?
I don't remember the exact names, but any state police sergeant in uniform would do.
Why do you want any state police sergeant to be present at the trial?
Just to show how arrests are made, and why they're made, and how they do the determination, how they bring people into jail.
Well, how is any of that relevant to whether or not you violated the terms of probation?
I believe there's a lot of relevancy there. I don't see where any of it's going to affect the courts in any way, shape, or form.
All right. So the issue that the court is going to determine has nothing to do with things that happened during your arrest. The issue is whether or not.
No, it's not about the arrest. It's about the arrest for the violation of probation as well.
All right. The only issue before the court that day is going to be whether or not you reported. So your arrest doesn't have any relevancy to that. So I'm not going to.
I beg to differ, Your Honor. I beg to differ because the jury is going to be a jury of my peers, and at this time,
sir,
you're not going to have a jury of my peers.
Sir, there's not going to be any jury. You're not entitled to a jury trial on a hearing about violating your probation.
I'm sorry, I misunderstood. I'm pretty sure that last time I spoke to you, you said that I had the right to a jury trial for determining if I was guilty for a violation of probation.
I've never seen you on this violation of probation.
I've seen you, or I've seen you just the other day, last week.
No, you didn't. A different judge conducted that hearing.
You're Michael Olsaver, aren't you? There was Judge Sloan, and then there was you. I've seen both.
You did not see me last week.
I did.
And so you're not entitled to a jury trial on a probation violation. So again, we will have you back in person on.
Well, hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying. Mr. Matson, I was saying that this is a criminal court wherein you have pled guilty to possessing a controlled substance, and you were placed on probation. As a result of that, your sentence was to be placed on probation. Subsequent to being sentenced to probation, there was an allegation that you failed to report in accordance with the terms of your probation. That is an alleged violation of probation. There's no right to a jury trial for a violation of probation, so the court will conduct. Let
me speak to.
I've muted Mr. Matson again because he unmuted himself and interrupted me. We will have you back on April 8th at 3:30, Mr. Matson. This hearing is concluded.
What begins as a routine probation violation hearing quickly transforms into a tense courtroom standoff, as Michael Matson enters determined not to address the charge itself, but to challenge the very authority of the court. The allegation is simple. A failure to report to probation is required. But instead of acknowledging or disputing that violation, Matson immediately shifts the focus away from the facts and toward a maze of legal jargon, procedural objections, and familiar sovereign citizen talking points. From the start, Judge Simpson maintains a calm and measured tone, carefully explaining the purpose of the hearing and ensuring the defendant understands why he's there. The judge outlines Matson's rights, including his right to legal counsel, emphasizing that this is an opportunity to be represented by an attorney if he chooses. Rather than giving a clear answer, Matson responds with confusion disguised as strategy. He claims he doesn't want full legal representation, but instead requests a public defender solely to assist him with paperwork. The courtroom pauses as the judge makes it clear that this is not how the system works. Attorneys are not assigned on a part-time basis to help defendants cherry-pick assistance while rejecting accountability. As Judge Simpson attempts to redirect the hearing back to the probation violation, Matson begins interrupting, speaking over the judge, and launching into rehearsed arguments. He questions the legitimacy of the proceedings and attempts to assert that the court lacks jurisdiction over him. The judge, clearly familiar with these arguments, responds without hesitation, stating that such claims have been raised and rejected many times before. There is no hidden legal loophole, no secret phrase, and no magic argument that exempts someone from probation requirements. Despite repeated explanations, Matson refuses to engage with the substance of the case. Instead, he demands to see proof of Judge Simpson's oath of office, insisting that without it, the judge has no authority. Judge Simpson firmly shuts this down, explaining that judges are not required to prove their legitimacy on demand, and that the courtroom is not a platform for ideological debates. The court's authority does not hinge on a defendant's approval. As frustration builds, Matson escalates his demands. He calls for a state police sergeant to appear in uniform to testify about how arrests are made. The request makes little sense in the context of a probation violation hearing, and Judge Simpson patiently explains that arrest procedures are irrelevant. The issue before the court is not how Matson was arrested, but whether he failed to comply with probation conditions he previously agreed to. The judge reiterates that the hearing is not a trial, not an investigation into law enforcement practices, and not an opportunity to cross-examine officers about unrelated topics. Undeterred, Matson insists on a jury trial, demanding a jury of his peers as if invoking a constitutional right automatically grants one. Judge Simpson explains, multiple times, that probation violation hearings do not involve juries. Probation is a conditional privilege, not an absolute right, and violations are handled by a judge, not a jury. The law on this matter is clear, settled, and non-negotiable. Throughout the exchange, Matson repeatedly interrupts the court, talking over the judge and refusing to wait his turn. The interruptions become so persistent that Judge Simpson is forced to mute Matson's microphone just to restore order. Even then, the defendant continues attempting to speak whenever the mute is lifted, ignoring warnings and procedural boundaries. The judge's patience remains steady, but his tone grows firmer as he makes it clear that the hearing will proceed with or without Matson's cooperation. Each time the judge attempts to move forward, Matson circles back to the same arguments: jurisdiction, oaths, witnesses, juries, none of which address the actual allegation. It becomes increasingly clear that this is not a misunderstanding, but a deliberate refusal to engage with reality. Judge Simpson explains that probation requires compliance, communication, and accountability. Failing to report is not a philosophical disagreement, it's a violation. As the hearing progresses, the courtroom dynamic becomes a study in contrast. On one side, a judge grounded in law, procedure, and patience. On the other, a defendant relying on internet-driven legal myths and sovereign rhetoric that promise control but deliver consequences. Judge Simpson makes it clear that the court will not argue ideology. The court enforces the law. Eventually, the judge regains enough control to address scheduling. Despite the disruptions, a follow-up hearing date is set. Even this administrative task proves difficult, as Matson continues attempting to interrupt, forcing the judge to mute him again. With firm clarity, Judge Simpson finalizes the next court date and outlines what will be expected moving forward. The hearing closes not with a dramatic ruling, but with a sobering reminder. Courts are places of law, not platforms for protest. Rights exist, but so do responsibilities. And no amount of legal wordplay can erase the basic requirement to comply with court-ordered probation. What unfolds in this courtroom is more than a single probation violation. It's a real-world example of how misinformation collides with the justice system, and how patience, structure, and authority ultimately prevail. The system may move slowly, but it does not bend to denial, and it does not negotiate with fantasies.